The marble chambers of the Supreme Court fell into a tense silence as Justice Amy Coney Barrett leaned forward, her steady gaze fixed on Elon Musk. The tech billionaire stood confidently at the petitioner's lectern, representing his companies, in a landmark case that could redefine the boundaries between government regulation and technological innovation. "Mr. Musk," Justice Barrett began, her voice carrying throughout the packed courtroom, "you've stated repeatedly that your satellite network operates beyond traditional regulatory frameworks. Yet you seem to want the protections of American law without the corresponding responsibilities." Her tone sharpened. "Isn't this simply a case of exceptional privilege? One set of rules for billionaires and another for everyone else?" The question hung in the air, deliberately framed to put Musk on the defensive. Several justices exchanged glances. The media representatives in the gallery began frantically taking notes, sensing the potential for a viral moment at the billionaire's expense. Musk paused, taking a measured breath. Instead of appearing flustered, a slight smile crossed his face. He gently placed his notes aside and stepped slightly closer to the microphone. "Justice Barrett," he responded, his voice calm and deliberate. "With respect, that framing fundamentally misunderstands what's at stake here. This isn't about privilege or exceptionalism." He held up a document that hadn't been referenced previously. "This is about the government attempting to apply 1934 communication standards to technologies that are literally beyond Earth's atmosphere. And I have here evidence that the regulatory agencies themselves acknowledge this legal gap in their private deliberations." Justice Barrett's expression shifted subtly from confidence to caution. She hadn't expected this direct challenge backed by unreleased evidence. "Furthermore," Musk continued, "I would suggest that what truly represents privilege is when established interests use outdated regulations as barriers to protect themselves from innovation that would benefit humanity." What happened next would transform a routine Supreme Court argument into one of the most consequential legal confrontations in modern American history, one that would reverberate through every aspect of technology regulation and ultimately make Elon Musk an unexpected champion of legal modernization. Before we dive deeper into this extraordinary legal showdown, make sure to hit that like button and subscribe to our channel for more in-depth analysis of today's most important conflicts between innovation and regulation. Turn on notifications so you'll never miss our coverage of the battles that are shaping our technological future. Justice Amy Coney Barrett had built her reputation on careful constitutional analysis and textualist interpretations. Appointed to the Supreme Court in 2020, the former Notre Dame law professor had become known for her incisive questioning and meticulous judicial philosophy. Her questions often cut directly to the core legal vulnerabilities in arguments presented before the court. In private conferences, Barrett had expressed concerns about the growing power of technology companies operating beyond traditional regulatory frameworks. The Constitution never contemplated private entities with nation-state levels of influence, she had remarked to her clerks while preparing for this case. "We need to consider carefully whether our existing legal frameworks are sufficient." The case before the court, Starlink Communications versus Federal Communications Commission, represented the culmination of a 3-year legal battle over regulatory authority for space-based communications networks. At its heart was a fundamental question. Could terrestrial regulatory agencies impose traditional telecommunications rules on orbital platforms, or did such technologies require a new legal framework? Elon Musk approached this Supreme Court appearance differently than his usual public engagements. Now, in his early 50s, the entrepreneur had matured beyond his earlier impulsive social media persona. His companies had evolved from speculative ventures into critical infrastructure providers, Tesla powering a significant percentage of America's renewable energy grid, SpaceX handling both civilian and defense space transportation, and Starlink, providing internet access to previously unconnected regions globally. For this appearance, Musk had personally prepared for months, working with constitutional scholars and technology policy experts. He understood that the implications extended far beyond his own business interests. The court's ruling would establish precedent affecting every aspect of emerging technologies, from artificial intelligence to biotechnology. This isn't just about satellite internet, he had told his legal team during preparation. This is about whether America's legal system can adapt to technologies that the original regulators could never have imagined. If innovation must always conform to outdated frameworks, we're effectively putting technological progress in reverse. The stakes were enormous. If the court ruled against Starlink, it would establish precedent, allowing agencies to apply legacy regulations to emerging technologies without congressional authorization. Such a ruling would potentially require Starlink to restructure its entire network at a cost of billions, potentially abandoning service to millions of users in remote areas where traditional internet infrastructure was economically unfeasible. Beyond the immediate case, a broader principle hung in the balance. Could America's legal system evolve to accommodate technological advancement, or would innovation be constrained by frameworks designed for a pre-digital, pre-space age? The courtroom reflected these high stakes. All 9 justices were present for the arguments. Every seat in the gallery was filled with technology executives, regulatory officials, and legal scholars packed shoulder to shoulder. Outside, protesters from both sides gathered, some arguing for stronger regulatory oversight of technology companies, others advocating for regulatory frameworks that would encourage rather than impede innovation. As Musk stood before the highest court in the land, the confrontation had transcended a mere regulatory dispute. It had become a pivotal moment in determining whether America's legal institutions could successfully navigate the accelerating pace of technological change in the 21st century. Justice Barrett regained her composure quickly, leaning forward with renewed intensity. Mr. Musk, the document you're referencing was not included in the official case record. The court cannot consider new evidence at this stage. Musk nodded respectfully. You're absolutely correct, Justice Barrett. However, this isn't new evidence in the legal sense. These are public records obtained through FOIA requests last month, after the case filings but before today's arguments. They demonstrate that the FCC's own Technical Advisory Committee concluded that orbital communications networks operate in a regulatory gap, not clearly covered by existing statutes. Justice Elena Kagan interjected, her interest visibly piqued. Counselor, are you suggesting that the FCC proceeded with enforcement actions while their own advisory committee was questioning their jurisdiction? That's precisely what happened. Justice Kagan, Musk replied, now directing his attention to the entire bench. The documents show that the FCC's technical experts specifically noted that the Communications Act never contemplated space-based networks serving global populations. They recommended that Congress establish a new regulatory framework rather than attempting to stretch existing authorities beyond their intended scope. Justice Neil Gorsuch, known for his skepticism of administrative overreach, leaned forward. And the commission proceeded anyway, despite this internal recommendation? Yes, Justice Gorsuch. The FCC leadership dismissed these concerns in an internal memo stating, and I quote, "We cannot wait for Congress to catch up with technological reality. We must assert jurisdiction now or risk losing it." A murmur spread through the courtroom. The Solicitor General, representing the FCC, rose quickly from her seat. Your Honors, the government objects to this characterization. The memos in question represent preliminary deliberations, not final agency positions. Chief Justice John Roberts addressed the Solicitor General directly. Counselor, are you disputing the authenticity of these documents? The Solicitor General hesitated momentarily. No, Your Honor, but we believe they're being presented without proper context. Justice Barrett, sensing the momentum shifting away from her initial challenge to Musk, attempted to redirect the argument. Mr. Musk, even if we accept that the regulatory framework is imperfect, your companies have still benefited enormously. From government contracts, NASA partnerships, and publicly funded research. Don't these benefits create some obligation to operate within established regulatory systems, even as they evolve? Musk turned back to Justice Barrett, his expression thoughtful rather than defensive. Justice Barrett, that's an excellent point that goes to the heart of the relationship between innovation and regulation. SpaceX and Tesla have indeed partnered extensively with government agencies, and we comply fully with all regulations that legitimately apply to our operations. What we're challenging is not regulation itself, but the retrospective application of frameworks designed for entirely different technologies. He paused, then continued with increasing passion. When the automobile was invented, we didn't simply apply horse and buggy regulations. We created new frameworks appropriate to the technology. The same principle applies here. Justice Sonia Sotomayor, who had been listening intently, joined the questioning. Mr. Musk, where exactly would you draw the line? If we accept your argument that orbital networks exist in a regulatory gap, what prevents any new technology from claiming exemption from oversight simply by being sufficiently novel? This question, striking at the core tension between innovation and regulation, seemed to energize Musk rather than challenge him. Justice Sotomayor, that's precisely the question Congress should be addressing, he responded. The proper role of courts and existing regulatory agencies isn't to stretch their authorities beyond recognition, but to identify when technological change has created genuine legal gaps that require legislative attention. He gestured toward the gallery, where several members of Congress were observing the proceedings. We're not arguing against regulation. We're arguing for appropriate regulation. In fact, Starlink has submitted detailed proposals to Congress, outlining a modern regulatory framework for orbital communication systems that would provide stronger consumer protections and security requirements than anything the FCC has attempted to impose using authorities from the radio era. The atmosphere in the courtroom had transformed. What had begun as an attempt to portray Musk as seeking special treatment had evolved into a substantive debate about the fundamental relationship between technological innovation and legal frameworks. Justice Barrett, recognizing this shift, made one final attempt to challenge Musk's position. Mr. Musk, while we wait for this ideal regulatory framework you're describing, what happens to the public interest? Who protects consumers and ensures system security in this gap you've identified? Musk nodded, acknowledging the legitimacy of her concern. That's a critical question, Justice Barrett. In the interim, Starlink has voluntarily adopted the most stringent security and privacy standards from multiple international jurisdictions. We've established an independent oversight board including former regulators and security experts. We're not arguing for no rules. We're arguing for the right rules properly established. As the initial argument period concluded, it was clear to everyone in the courtroom that what had begun as an attempt to embarrass Musk had instead provided him with a platform to articulate a sophisticated position on technology regulation that transcended the immediate case. The justices' questioning had shifted from skeptical to engaged, with several appearing receptive to the core distinction between appropriate regulation and retrofitting outdated frameworks to new technologies. The Chief Justice announced a brief recess before the government would present its counter-arguments. As the justices rose to exit the chamber, the gallery buzzed with conversation. Legal observers noted the unusual dynamics of the argument. A technical entrepreneur had effectively reframed a complex regulatory dispute into a compelling case for legal modernization, turning an initially hostile questioning into an opportunity to advance a broader vision. When the court reconvened, the dynamic had fundamentally changed. The Solicitor General, representing the FCC, approached the lectern with visible trepidation. What should have been a straightforward defense of regulatory authority had become considerably more complex. Your Honors, she began, the government acknowledges that space-based communications present novel regulatory challenges. However, Congress has granted the FCC broad authority over all forms of communication by wire or radio, regardless of their physical location. Justice Clarence Thomas, who had been silent during Musk's presentation, spoke up. Counselor, How do you respond to Mr. Musk's evidence that the FCC's own technical advisors question this interpretation? The Solicitor General hesitated. Those were preliminary discussions, Justice Thomas. The Commission's final determination, approved by a majority vote, was that existing authorities are sufficient. Justice Brett Kavanaugh leaned forward. But isn't that determination itself a significant expansion of regulatory authority without explicit congressional approval? The major questions doctrine would suggest such expansions require clear legislative authorization. As the government's case began to unravel under increasingly skeptical questioning from both conservative and liberal justices, Musk sat quietly at the petitioner's table. The laptop before him displayed incoming messages from observers, noting the remarkable turnaround in the court's approach. When the time came for rebuttal, Musk returned to the lectern with renewed confidence. Your Honors, this case ultimately presents a choice between two visions of America's technological future. One vision, the government's position, would constrain new technologies within regulatory frameworks designed for their predecessors, inevitably hampering innovation and America's competitive position. He paused, making eye contact with Justice Barrett, whose initial challenging questions had now been answered comprehensively. The alternative vision recognizes that technological advancement sometimes creates genuine legal gaps that require thoughtful, deliberate attention from Congress, not regulatory overreach. This vision maintains America's position as the world's innovation leader, while ensuring appropriate oversight through properly authorized channels. Musk concluded with a statement that would be quoted in every news report of the proceedings. The question isn't whether technologies like satellite networks should be regulated. Of course they should. The question is whether we have the institutional wisdom to recognize when we need new legal frameworks, rather than stretching old ones beyond recognition. That wisdom, the ability to adapt our legal structures to technological reality, has been central to American innovation leadership for generations. As Musk finished his presentation, even the most experienced Supreme Court observers were struck by the transformation that had occurred. What had begun as an attempt to portray him as seeking special treatment had instead provided a platform for articulating a sophisticated vision of adaptive technology regulation that had visibly resonated with justices across the ideological spectrum. Outside the court, a swarm of reporters awaited Musk's emergence. When he appeared on the iconic steps, cameras flashed and microphones were thrust forward. Rather than appearing triumphant or combative, Musk projected thoughtful determination. Today wasn't about winning a case for Starlink, he told the assembled media. It was about ensuring America's legal system can evolve alongside our technological capabilities. Whatever the court ultimately decides, I hope this case begins a more productive conversation about how we regulate emerging technologies. The statement, broadcast live across multiple networks and shared millions of times on social media platforms, represented a striking evolution in Musk's public persona. The entrepreneur, often portrayed as impulsive and controversy-seeking, had presented himself as a serious advocate for legal modernization, earning grudging respect even from longtime critics. Legal analysts appearing on evening news programs noted the surprising effectiveness of Musk's arguments. Justice Barrett clearly intended to challenge Musk's position in her opening questions, remarked constitutional scholar Rebecca Jameson on a major network. But rather than becoming defensive, Musk redirected the conversation toward the fundamental issue of regulatory appropriateness. It was a masterclass in legal argumentation from someone who isn't even a lawyer. Technology policy experts highlighted the broader implications. Today's arguments could influence how we regulate everything from artificial intelligence to autonomous vehicles, explained Dr. Michael Chen, director of the Technology Policy Institute. Musk effectively articulated why forcing transformative technologies into outdated regulatory boxes ultimately serves neither innovation nor the public interest. By nightfall, the hashtag #JelonMuskVsBarrett was trending globally, with millions sharing clips of the exchange. But unlike many viral Supreme Court moments, The conversation wasn't focused on personal conflict or political divisions. Instead, Americans across the political spectrum were engaged in a surprisingly substantive debate about the proper relationship between technological innovation and legal frameworks. What had begun as an attempted judicial embarrassment had transformed into one of the most important public conversations about technology regulation in decades, with Elon Musk emerging as an unexpected champion of thoughtful regulatory modernization. 3 months after the Supreme Court arguments, the justices issued their ruling in Starlink Communications versus Federal Communications Commission. In a surprising 7-2 decision authored by Justice Barrett herself, the court sided largely with Musk's position, ruling that while the FCC retained general authority over communication systems, it could not apply terrestrial telecommunications regulations to orbital networks without clear congressional authorization. When regulatory statutes are applied to technologies fundamentally different from those contemplated by Congress, Barrett wrote in the majority opinion, courts must carefully consider whether such application represents legitimate interpretation or unauthorized expansion. In this case, we find the Commission exceeded its statutory authority. The decision represented a significant victory not just for Starlink, but for the broader principle that technological innovation sometimes requires updated legal frameworks rather than stretched interpretations of existing ones. Legal experts noted the court's unusual harmony, with both conservative and liberal justices finding common ground in limiting regulatory overreach while simultaneously acknowledging the need for appropriate oversight. Justice Barrett's evolution from skeptical questioner to author of the majority opinion became a subject of extensive commentary. In a rare post-decision interview with a legal publication, she acknowledged the impact of the oral arguments. Sometimes a case looks different once you hear the full presentation, she explained. Mr. Musk articulated a nuanced position that respected the importance of regulation while identifying genuine gaps in our current framework. That's exactly the kind of argument that can bridge ideological divisions on the court. The ruling catalyzed immediate action in Congress, where a bipartisan group of senators introduced the Space Communications Regulatory Modernization Act. The legislation, developed with input from industry, academic experts, and consumer advocates, established a comprehensive framework specifically designed for orbital communication networks. Today we're doing what Congress should always do, updating our laws to address technological realities, said Senator Maria Rodriguez during the bill's introduction. Rather than forcing agencies to stretch old authorities beyond recognition, we're providing clear, appropriate guidelines that protect the public interest while enabling continued innovation. For Musk personally, the Supreme Court confrontation marked a significant evolution in his public image. Once widely perceived as an impulsive provocateur, he was increasingly viewed as a serious advocate for thoughtful regulatory modernization. Invitations to speak at prestigious law schools and policy forums poured in, providing platforms to further develop his vision of adaptive regulation for emerging technologies. 6 months after the Supreme Court decision, Musk delivered the keynote address at the National Conference on Technology Law and Policy. His speech, titled Adaptive Regulation for Accelerating Innovation, proposed a comprehensive framework for addressing the gap between technological advancement and legal evolution. The challenge we face isn't choosing between innovation and regulation, he told the assembled judges, legislators, and legal scholars. It's developing regulatory systems that can evolve at a pace closer to technological development. When the gap between technological reality and regulatory frameworks becomes too wide, both innovation and public protection suffer. The address received widespread praise across the political spectrum, with former critics acknowledging Musk's unexpectedly sophisticated understanding of administrative law and regulatory policy. Harvard Law School announced the establishment of the Center for Adaptive Regulation and Technological Innovation, inspired in part by the principles articulated in Musk's address. Perhaps most significantly, the confrontation with Justice Barrett and its aftermath transformed the broader conversation around technology regulation in America. Rather than the often polarized debate between unfettered innovation and rigid control, a more nuanced discussion emerged about designing regulatory frameworks appropriate to emerging technologies. The Barrett-Musk exchange, despite its initially adversarial nature, ultimately demonstrated how seemingly opposed perspectives can lead to better outcomes, wrote legal scholar Jonathan Ramirez in a widely circulated analysis. Barrett's legitimate concerns about regulatory gaps met Musk's vision of appropriate rather than retrofitted regulation, producing a synthesis that serves both innovation and the public interest. 1 year after the Supreme Court arguments, a Gallup poll showed 78% of Americans believed that regulations for new technologies should be specifically designed for them rather than adapted from existing frameworks. A striking consensus in an otherwise divided political landscape. This shift in public understanding created space for more productive policy discussions across a range of emerging technologies from artificial intelligence to biotechnology. For Starlink, the practical impact was immediate and substantial. Freed from inappropriate regulatory constraints while operating under the newly established framework, the network expanded its coverage to previously underserved rural communities across America and developing nations globally. Within 2 years, an additional 400 million people gained internet access through the system, with particularly significant impacts on education, healthcare, and economic opportunity in remote regions. On the second anniversary of the Supreme Court arguments, Justice Barrett and Elon Musk made a rare joint appearance at Georgetown Law School's annual conference on technology and the law. Their discussion, moderated by the dean, revealed how their thinking had evolved through their confrontation and its aftermath. I approached that case with legitimate concerns about regulatory gaps, Barrett acknowledged. What I came to appreciate through Mr. Musk's arguments was that inappropriate regulation can be as problematic as no regulation. The challenge for our legal system is determining when existing frameworks can be legitimately applied to new technologies and when we need to acknowledge that innovation has outpaced our current authorities. Musk nodded in agreement. And what I've come to better appreciate through Justice Barrett's questioning is that identifying regulatory gaps isn't enough. We have a responsibility to actively participate in developing appropriate replacements, not just advocate for freedom from outdated constraints. This unlikely intellectual partnership, the textualist Supreme Court justice and the visionary entrepreneur, symbolized a more productive approach to the fundamental challenge of governing rapidly evolving technologies in a constitutional democracy. Their initial confrontation, which began as an attempt at embarrassment, had evolved into one of the most consequential legal dialogues of the early 21st century. The question was never whether technology should be regulated, Musk concluded in his closing remarks at the conference, but whether we have the wisdom and flexibility to create regulatory systems that protect the public while allowing innovation to flourish. That challenge will only grow more significant as technologies continue to transform our world at an accelerating pace. As the audience rose in a standing ovation, observers noted that what had begun as a tense confrontation had transformed into something unexpected, a model for how productive engagement between technology leaders and legal institutions could help America navigate the unprecedented challenges of the digital age. If you found this analysis of the historic Barrett-Musk confrontation enlightening, please hit the like button and subscribe to our channel for more in-depth coverage of the crucial intersections between technology, law, and policy. Turn on notifications to stay updated on how these legal principles continue to shape the future of innovation in America and beyond. Leave a comment below sharing your thoughts on how we should balance regulation and innovation in emerging technologies.